Hello and welcome to the Rodgers Brief for September 15th, 2023. I'm Adam Rodgers. Thank you for watching and thank you for listening. Welcome back after a summer hiatus for the Rodgers Brief. We took a few months off there. I hope everybody had a good summer. We're mid-September now, so everybody's certainly back into the swing of the school routine and the work routine and past their vacations probably. Had a good summer myself, lots of ball fields, soccer fields, beaches, doing some kayaking and paddleboarding. Haven't been completely silent. I've been still appearing regularly with Jordan Bonaparte and Paul Palango on the Sunday night show, the newly named, I guess, Sunday night show. And so people may have been tracking things there, but it's been a busy summer in some ways in the legal world. A lot of it's been down in the United States with the president, former president, with all of his indictments, and then the son of the current president, that is Hunter Biden, now being indicted as well. I'm not going to talk about that today. That's just sort of what's been happening over the summer. Courts usually, at least in Nova Scotia, probably throughout Canada, slow down a little bit during the summer. Certainly in August, it tends to be a time when lots of judges certainly take their vacations and stuff, but it was still ongoing. Actually, just this week, I had this is September, I guess, but had a case with a good decision on a charter case. Maybe I'll mention this quickly before I get into some of the bigger stories of the week. It was a decision on a roadside stop. So people are very familiar probably with checkpoints for alcohol. Well, now with the legalization of cannabis, there's been a development of testing for THC, and there's some limits on that. So what the police do is they'll do a swab of saliva, and then they'll test that as sort of a preliminary, and then if you're over a certain limit, then you get taken to a hospital. Very disruptive. You get taken to a hospital for a blood sample to be taken. And the blood sample can't even be tested at the moment. It has to then go off to a lab, and you come back, and you may or may not get a result right away. It's usually weeks before you do. Anyway, a little difference. This case was a charter decision, and it went in my client's favor. And it was a situation where he was in a truck with a passenger. Police officers smelled a little bit of a burnt marijuana, so not fresh, out of the truck, and formed a suspicion. Now, in order to justify putting somebody to the saliva test, or in the case of alcohol to the original ASD, you have to have a reasonable suspicion. And it's a low standard, but it requires some evidence. Well, in this case, the officer smelled some cannabis coming from the truck itself, which had cloth seats, and anyway, it was. But then when the driver came out to the back of the truck, officer smelled nothing. No signs of impairment, no erratic driving behavior, none of those other indicia. So the judge says, well, that's a violation. You had maybe a generalized suspicion about the truck, but nothing specific to the driver once the driver was isolated from the cabin of the truck. So anyway, good decision. Just one other thing I mentioned on this, people may not be aware because it's fairly new still, but many people would argue that having a certain level of THC beyond the level that's considered illegal is much less dangerous than being over the alcohol limit. But if you're convicted or plead guilty on the alcohol limit, the driving prohibition is supposed to be a year. Well, you can get the interlock device installed in your vehicle, and you can be driving practically the next day. You can be driving almost right away. You can qualify for it right away. There's no equivalent for cannabis consumption. And if you're just slightly over the THC limit, you get a year suspension of your license, and there is no alternative. So probably something that should change. Not a lot of people trying to see how impaired drivers can be treated more fairly, but I think that's one way that we could certainly look at. Anyway, I want to talk about some of the stories of the week. There's some political stories. There's some cases out of Nova Scotia. I'm going to talk about the Halifax Alehouse situation that's ongoing. elections Nova Scotia. There was a by-election in Nova Scotia in the Preston riding, which the governing PCs won, but there was some elections Nova Scotia issues going on there. And then I'm going to talk about two that are a little more national in scale. One is about the trucker protests, the Tamara Lich, Chris Barber trial. It's going on in Ottawa at the moment. And then the Canadian Civil Liberties Association has filed a lawsuit against the New Brunswick government. And I see other provincial governments are either talking about or doing this. And it's all about education policy and whether a student can use their own pronouns and use their own, determine what their name is going to be in sort of official, formal educational setting without their parents being informed about that or without parental consent. So Civil Liberties Association is challenging the New Brunswick government on that, so I'll discuss that a little bit as well. But first, just talk about a couple of political stories. One is this, there were two cabinet shuffles, a federal and a provincial cabinet shuffle. Federally, the cabinet shuffle was about mid-summer. We have a new, I don't want to talk about the overall shuffle, which was largely seen as not very impactful. We do have a new federal justice minister. It's a bit of a surprise in a sense that David Lametti, although he wasn't seen to be doing a great job, he was taken out of cabinet completely, which is a very big demotion. And the parliamentary secretary to the justice minister, Arif Virani, a member of parliament from Parkdale High Park, that's in Toronto, actually, where I used to live in Toronto way back when, before law school, I think in 2000, 2001, I was out there. So we have a new justice minister, as a lot of waves, a couple of months that he's been in the role. Nova Scotia just had a mini cabinet shuffle. There were 30 ministers or so changed portfolios federally. Nova Scotia, there was just a handful, but the Justice Minister, Brad Johns, has remained in that portfolio. There was some speculation that he would be moved to somewhere else, but he's still the provincial justice minister. So no change in policy approach or tone expected as a result of all that. The other thing I wanted to mention, I guess politically, is just give some reflections of my last weekend. I was up in Quebec City, and this was for the Conservative National Convention, National Conservative Party Convention. They do this every couple of years. This is my third convention I attended. There was one in 2018 in Halifax, and I also went to one in Toronto back the mid-2000s, 2007 or 8, somewhere there. Anyway, these conventions are interesting times. You get to meet people from across the country, and Quebec City is just an awesome city to visit, so that's always a good idea. Some of the events during the convention and hospitality suite events took place in the garrison grounds at the Citadel in Quebec, and so that's always neat to see the history of Quebec City. Cobblestones. Went for a run along the St. Lawrence River up into the Plains of Abraham, the Battlefield Park, and then had a meal one night with a bunch of delegates from the Cape Breton and Eastern Nova Scotia. The restaurant we went to was like one of the original houses in Quebec City from the 1600s, so lots of history in Quebec City. The convention itself, lots of enthusiasm, some probably misconceptions about a conservative convention mentioned. One is people are very nice, they're very friendly, everybody from across the country. Lots of young people there, which is not always the case with conservative events. That seems to be an emerging trend. And lots of Nova Scotia content. People think of this as a Western party. Not the case. The outgoing president of the party, Rob Batherson, who spoke Thursday night and did a lot of the policy process, led that Nova Scotian, and Peter MacKay, who spoke to a packed audience on the Friday at lunchtime. Nova Scotian, lots of Nova Scotian delegates there as well. The policy process is pretty interesting in a way. If anybody's into policy, there's sort of 3 steps. To even get to the convention, a policy needs to be proposed by a local riding association. it has to get support from a few other riding associations from outside the area, and then it gets to the convention. And then step one at the convention is it's a closed to the media room, and you get a few speakers that get 30 seconds each, speak in favor of it, people speak against it, and then it's raise the card, red or green, against or for. And then if of those, of the 30 or 40 or 50 in each session, that the top 10 by percentage of support then go to the overall second session, which is the public session. People get their electronic beepers. People from across the country vote on these. So the part that was televised, people may have seen on the Saturday, is the result of, that's the third step in a process. And so only the most, I guess, popular within the party policies get that far. Of course, there was policies on the carbon tax and removing that. Justice-wise, it wasn't a lot of justice policy debated. One was about the bail system, and for serious offenders, the most serious offenders, that it should be tougher to get bail for those kind of individuals. So that policy proposal passed pretty handily, and some free speech, bodily autonomy stuff as well. So that was all very good, and so that was the weekend in Quebec City. I always encourage people to go to Quebec City if they ever have a chance. Okay, so now I'm going to move into some of the specific cases that are ongoing. One that's been in the news quite a bit in Nova Scotia is this Halifax Alehouse case, and there's a manslaughter and criminal negligence causing death charges against against the bouncer, the death of a guy named Ryan Sawyer from last Christmas, and then there's assault charges. 2 bouncers are up on assault charges, but that's not what was in the news this week. So the Alehouse, popular bar in Halifax, for those not familiar, is also facing a Provincial Liquor Control Act series of charges. The 2 charges are, first, that they allowed activity detrimental to the order of the control of the premises, which must be a high standard, because that's basically what a bar is. Second is they did not report the criminal charges to the liquor board, the criminal charges that are being faced by the bouncers. So you're supposed to do that, apparently. Well, what made the news this week was that the lawyer for the Alehouse, Victor Goldberg, well-known lawyer in Halifax, says that the process should be confidential in order to protect the fairness of the criminal trials of the 2 bouncers. So it's like, oh, well, yes, I guess so. You should protect the integrity of a criminal trial. That seems important. We saw that issue come up a little bit during the Mass Casualty Commission, when the inquiry was doing certain things, and they were waiting to hear when Lisa Banfield's trial would be over and whether they could call her as a witness and all these other things. But in that case, it was Miss Banfield's lawyer making the argument. In this case, it's not the lawyer for the bouncers making the argument that their trials should be protected. It's the lawyer for the Alehouse saying, hey, this process where the Alehouse is going to be, put on subject to hearings under the Liquor Control Act should be secret, should be not public, to protect the bouncers. Really what he's doing is trying to protect the Alehouse. In my view, he's the Alehouse's lawyer, not the bouncer's lawyer. So not sure what the Liquor Control Board will do with that. I suspect they'll dismiss that and make the process public. And, on the criminal court side, the judge, if it's a judge alone, will have to disregard it. If there's a jury involved, I'm not sure if there would be a jury option with that manslaughter charge. Perhaps there would be if there's an election for a jury. Then there'll be some special instructions to disregard anything that may have read about the Liquor Control Act hearings. All right, so that's one Nova Scotia case. The other one was from the summer, but it started in the summer, but it's now just been, I don't know if the claim has been filed. I haven't seen the claim itself, but the news of the claim has come out this week that the Liberal Party of Nova Scotia is asking the court to make a declaration about the Elections Act. So what happened during the by-election the Liberals candidate had put up a sign that said that the PC government was doing nothing to stop the dump. The dump being this proposed action on a landfill site potentially taking place in the riding. Well, the PCs complained to Elections Nova Scotia that the ad was misleading, that there wasn't anything, there was no proposal to consider, there was nothing happening, so it was a misleading sign, and Elections Nova Scotia agreed with them, told the Liberal Party candidate to take the signs down. Candidate did not do so immediately, and so Nova Scotia called in the RCMP. So now the Liberal Party is saying, well, they're not questioning the result of the by-election. It wasn't that close. They are seeking clarity for the future on two things. First of all, they want the court to quash the declaration that the sign was misleading. Argument being, well, proposal or not, the government wasn't doing anything about the dump, and so they're doing nothing to stop the dump. Not the most unreasonable position, and not the most unreasonable thing to put up on a sign, perhaps. So the Liberal Party looking to have that a declaration that the decision was a wrong decision at the time. And then also, they want to make this section 307 of the Elections Act, which a section says you cannot knowingly make false statements of fact about a candidate's character or conduct. Lots of wiggle room in there. You would think just knowingly what is false, what is it about their character or conduct. Anyway, to make that section subject to the Charter of Rights and Freedoms, which would incorporate, freedom of speech and those sorts of things. I think it is already subject to the Charter. I'm not sure why they would want to make that explicit. It's government legislation about government actors, so to me that's already subject to the Charter, but we'll see what happens with that. Some questions about the Chief Electoral Officer and their decisions. All right, next story. This is an ongoing trial. I haven't watched the proceedings themselves, but I've been following the news quite closely. This is Tamara Lich and Chris Barber trial. Really interesting proceedings going on. Of course, everybody be familiar with the Freedom Convoy, the Trucker Convoy, the Occupation of Ottawa, whatever you want to call it, and then the Emergencies Act inquiry, which covered in the spring. Well, now two of the purported leaders of the movement, of the convoy, of the protest, are being charged with mischief, which sounds, sometimes people that aren't familiar with the law, it sounds, oh, you're being mischievous. No, well, it's causing damage to property, basically, is what it is. And then counseling others to commit mischief. Intimidation and obstructing police. This is under Section 423.1 of the Criminal Code. And then Mr. Barber is also charged with counseling others to disobey a court order. The court order being an injunction against honking the truck horns late at night, beyond certain hours of the night. So they're playing video and social media posts and all these things. One of the posts on the last issue of the honking of the horns was that Chris Barber said on the video, yes, the injunction's in place, but if you see a big police presence coming your way, lay on the horns, basically, is what he said. So, not sure exactly. Anyway, that may be probably try to argue that that's a justifiable exception to the injunction, or that it's not dealing with the harm that was trying to be addressed by the injunction, which was just try to keep the peace in the neighborhood. Well, if the police are going to try to take advantage of the injunction, knowing that you can't alert anybody by honking your horns, and then they go in at that time, well, that's a little unfair as well, and maybe justifies an exception. So this is it's an all interesting thing, because there's a number of facets to this. One is, do you try these two together or separate? They're being tried together, and some of the Crown is making efforts to have evidence against one count as evidence against each other. But they're introducing all these social media posts where it's only one of them, or it's neither of them, and it's just evidence from the protest. And it's not always clear. The other part is, were there any real leaders of this protest? Of course, there were more prominent individuals, and of course, some people seem to do what they said, but it wasn't organized in the hierarchical fashion that I think the Crown is hoping the court will accept. In some ways, this seemed to be, from the outside looking in, something of a leaderless movement. So in order to be found guilty of counseling somebody, there must be a causal relationship between the statement you make, let's everybody come to Ottawa, and everybody, let's shut the place down and all that stuff. A causal relationship between any statement made and then the actions. Nobody was telling protesters, and these two weren't at least, to, break windows and bust things and all that. The other side of it is, what you say is relevant, but you also have to have the intent that what you say, you know that if you say something, it is likely to be done, or that there's a high risk that it will be done. If you say, all right, everybody, we're going to go down, Wellington Street, and we're going to block that street. Well, if you know that if you say that, people are going to do it, well, then that could count as counseling. But here's another issue, which was the first police witness who said that the convoy organizers tried to meet with the police, tried to meet with the city officials to sort of plan out, okay, here's where we'll park. We will allow some traffic to go through. It'll go slowly, but this is a protest. That's how that works. We won't shut down the whole place. We'll just go in these designated areas, and we'll protest at these sort of designated times. It seemed like they had that in mind, at least, that they were going to propose that. And then nobody on the other side, on the police side, on the city side, engaged with them. And so therefore, the protest became more of an occupation. So I think the judge is going to struggle with that a little bit, because what you're allowed to protest. Everybody has a charter right to do that, and that's going to be a little bit disruptive. You can't say you can protest, but you can't disrupt anybody. That's part of what a protest is and does. So at what point does that turn from protesting charter-protected behavior to criminal, inducing counseling of mischief? We'll see. The other part of this is that it's scheduled to be a long trial. It's going to be 14 days, originally scheduled for 14 days. Looks like it's already going to be going longer than that, because some of the first few days were taken up with wrangling over evidence. The judge was very upset by this. The lawyers looked very disorganized, especially on the Crown side. Late disclosure, late indications of which social media posts from the organizers or people connected with the protest would be introduced, and for what purpose. The defense saying many of these are irrelevant. They don't originate with either of the accused, don't mention the accused, comment on any of these. They're just sort of, inflammatory from the defense perspective, trying to make it look like these two accused were more involved maybe than they were. Okay, so we'll be watching that. Looks like it's going to be going on for another couple of weeks, so we'll keep you updated on significant developments in the Tamara Lich, Chris Barber trial. Last thing I want to talk about is the Canadian Civil Liberties Association lawsuit against the government of New Brunswick. Very politically charged situation. So the Minister of Education and the Premier's been leading this in a sense from a public relations standpoint, but there's this policy 713, and the government made some amendments to this policy, which the Canadian Civil Liberties Association wants quashed. They want a declaration that the changes contravene the Education Act, the Human Rights Act, and the Charter of Rights and Freedoms. So what is it? Well, the school and the teachers for students that are under the age of 16 are not to use the students' if preferred or chosen pronouns or names. If the student so if a student is a transgender or non-binary student under the age of 16 years old, then the school and the teachers are not to, in any formal sense, use their chosen, preferred pronouns or names without parental consent. So, if under the new policy, the old policy was you didn't need parental consent, you just used it if that was seemed appropriate. And now, if there's no parental consent forthcoming, or the student doesn't want to ask for parental consent, then they are to be directed to a school professional, some sort of counselor or something like that, which it's not quite clear what that might mean, because there's no, as the Civil Liberties Association points out, just going to talk to a counselor or something like that, it might help, I guess, but there's no guarantee of when it might take place or how helpful it might be. Or even if you go to see the counselor and you still decide you don't want to talk to your parents about this, there's no option for them the school to then still use your chosen or preferred pronouns and names. So this is seen by those on the transgender advocacy world as a really big problem, that you're what they call dead naming or misgendering students, and that can be traumatic and harmful to their psyches. And so, anyway, I have some number of thoughts on this. I'm going to watch this very closely. I kind of suspect, the outcome I suspect is that the policy will be seen to be non-charter compliant. The courts will agree with the Civil Liberties Association, and it will need to be, the government will need to refine the policy, or invoke the notwithstanding clause. Wouldn't be surprised if the government did this. I mean, I think they're finding it to be a very popular policy politically, even though it's, probably a violation of the students' charter rights. What really struck me, though, was whether there needs to be a policy at all. Like, why isn't this just being done on a case-by-case basis? It struck me as a parent of a child in school that if you don't know that your child is transgender, if you do not know that they are trying to use another name or go by another pronoun, then you probably don't know your child very well. And if that's the case, maybe your consent to their situation and their changes, their desires, isn't all that important and needed. Is the policy needed? Can we not trust some people in the school and the teachers to deal with these situations? Some 15-year-olds are much more mature than others. I deal with students this age coaching and just being around them. So why do we need an overall provincial-wide policy? I think it's just something that the government is doing to inflame fears among parents, grandparents, about what may be going on in schools. Don't see this as a super major problem, but we'll be watching the case as it goes on. The Civil Liberties Association is also attacking the process by which this change came into place, saying that there was very little consultation done, no consultation with experts, really not much consultation with anybody. It was just brought in. And I suspect it's something that the government is using, and other governments. I see this is being brought up in Saskatchewan. I wouldn't be surprised if other provinces start looking at this as well. In Ontario, I think they started talking about it. That it would be a popular, perhaps politically decision, inappropriate in terms of Charter of Rights and Freedoms and the rights of students. So we'll see what happens there. In the case in New Brunswick. So they're up to about half an hour. That's the first go back for the Rodgers Brief. I'll be joining Jordan and Paul on Sunday night. We're going to do the Sunday night show. This is really fun Although now I'm trying to figure out, stories that we do on the Sunday night show versus stories that I cover here on the Rodgers Brief. Like Jack White trying to figure out what's a White Stripes song and what should go on the solo album. But anyway, that's the way this works. So, thanks everybody for watching. Thanks for listening. We'll see you Sunday night if you're joining me there. And a big hello for people that have stayed on this long. Hello to many of the people I met in Quebec that were friends of and fans of the Rodgers Brief. Appreciated meeting you there in person, and people from Nova Scotia and other provinces that have been following along. So appreciate the support and the kind words. So until next week, thanks for watching, thanks for listening, and we'll see you next time.